on domestic violence and guns, what it takes to build safe communities. My name is Paul Durenberger. I'm on the executive committee for the California Family Justice Center Network. I want to thank you all for participating. I also want to thank our illustrious panel for volunteering their time to be able to enhance our knowledge on what it takes to actually build a positive, progressive, and a working program when it comes to gun violence and gun relinquishment. Our focus today will be on community gun relinquishment programs, and it'll be focused on safety for community members impacted by family and interpersonal violence. This has been a priority issue for the California Family Justice Center Network, and unfortunately, it really came into focus for those of us that live in Sacramento, as I do, earlier this year. And to talk a little bit about that before we really get into our panel discussion, I want to introduce a colleague of mine who I consider a close friend. I hope you know that, Joyce. Joyce Ballou, Deputy Director of Sacramento Regional Family Justice Center. Joyce, if you could kind of start us off today with kind of what the impact was for the Sacramento community and the Family Justice Center when we had that tragedy in Sacramento.
Sure, thank you. And I'm just so honored to be here today and just doing another good part for Domestic Violence Awareness Month in October. So just a little background here. Women are 5 times more likely to be murdered by their abusive partner when their abuser has access to guns. So in February here in Sacramento County, a father killed 4 people, including himself. So he had 3 daughters. He killed all 3 of those before shooting himself. And he was at a Sacramento area church that he attended. There was 5 people dead. Like I said, his 3 kids. The person that was supervised, it was during a supervised visitation at this church. So he was a 39-year-old gunman who fired inside the church's name is called The Church in Sacramento, where a supervised visit between him and his daughters was taking place. The 3 girls killed where they were 9 years old, 10, and 13 years of age. And the other man was chaperoning the family that was also gunned down. This was not a random act of shooting. They all knew each other's. The shooter wasn't supposed to have a gun, and his restraining order didn't stop him. There are some risk factors. I did the, just based on the information that I've read in the newspapers and on the public restraining order, I did the danger assessment that Dr. Campbell puts together, the 20 danger assessment. So the father, can you go to the next slide, please? The father had a history of domestic violence and past threats to kill his victim. He was court ordered to a minimum of 16 hours of anger management. He had a restraining order in place. He had a history of strangulation. And if a victim's been strangled at least 1 time, they're at 50% at risk for homicide. He had access to weapons. He was controlling and very jealous. His violence was increasing. The survivor was in the process of leaving, and leaving, as many of you know, is often the most dangerous time for survivors. And others knew about something was going on in the situation. And if you look at the next slide, the impact that it had on our community, these are just a few. It had a tremendous impact, not only on our community, but around the country. There was a lot of community forums held. People came together to process and come up with solutions. A lot of candlelight vigils by family and friends and just the community overall. One of the things that we noticed here at the Sacramento Regional Family Justice Center, many clients, and I don't mean just 1 or 2 or 3, many of them came in with this tremendous, overwhelming fear that it was going to happen to them because their partners were saying that it was going to happen to them. We looked at our legal team here and we reviewed our policies around domestic violence restraining orders, in particular when it came to the supervised visitation piece. We conduct the danger assessment on clients and the strangulation assessment. We do it on every client that comes through our doors. And one of the things that changed here is we started tracking on our intake sheets who has, if their partner has access to guns. And just from June through the end of September, over 30% of our clients report that their partner has access to gun. I was really surprised once we started tracking this, just how high our number is getting. We do safety planning on every survivor, and we really understand the importance, how important it is to train officers and 911 dispatchers on identifying high risk cases. So we've been implementing that. We've created a curriculum and started training dispatchers and law enforcement on the danger assessment in particular for their own safety too. So to conclude, on the last slide here, I would just like to say that this guy, he killed his kids and he killed an innocent man who was supervising his children. These kids were innocent. They didn't have a chance at life. And it really hurt. It not only hurt the community, but it really, I can't even imagine what these three little girls' mother is feeling. It's just unbearable. It's unspeakable. And it's got to be the worst pain there ever a person can go through. So today's discussion is going to focus on some steps that we as a community and communities around the country and around the state can take to prevent other incidents like this. So you're all going to be hearing from a lot of experts around the country on this. So thank you.
Paul, you're muted.
Paul, you're muted.
Thank you. Thank you, Joyce. Obviously, this hit us in Sacramento in a very personal and not just personal, but in a very familiar way, because this is not the first and it won't be the last kind of shooting that has happened in Sacramento. And unfortunately, if you watch the news today, you see this repeating over and over and over in communities all across our country. So that's one of the reasons we are here today, to talk about this issue, to try to do our best to create programs in our communities that can help make people safer. So it's now my pleasure to introduce our panel. I'm going to go through each person's name and give you some props for your expertise. So please be patient with me. We're going to start with Julia Weber. Julia has combined degrees in law and social work and is really a one-woman powerhouse on domestic violence policy. That is not even an exaggeration. She spent her career working to develop and implement promising practices on family law issues. She currently serves as Giffords Law Center's implementation director. She focuses on identifying ways to most effectively implement gun safety policies. She originally joined Giffords Law Center in 2018 and is focused on gun violence restraining orders and extreme risk protection order implementation. Prior to joining Giffords, Julia worked for 17 years with the Judicial Council of California's Center for Families, Children, and the Courts, where she served as co-counsel to the Family and Juvenile Law Advisory Committee and supervised the Access to Justice Unit. She will speak today on what's commonly known as SB 320, a current recently passed California law, to try to talk about gaps and opportunities to support implementation. We are also very honored to have Supervisor Don Horsley, President of the San Mateo County Board of Supervisors, with us today. Thank you, Supervisor. He is also a former sheriff of San Mateo County, and with that extraordinary combined perspective, he has helped to champion best practices in San Mateo County, which we are very excited to learn more about. And then, speaking of best practices, we are also going out of state today. We are honored to have some special guests with us from Nashville, Tennessee. Diane Lance, Department Head of the Metro Nashville-Davidson County Office of Family Safety, and Becky Owens-Bullard, Senior Director of Programs. Diane currently serves as the department head, reporting directly to Nashville's mayor. She spearheaded the creation of this department, a model that has been replicated across the country. She works to improve the coordination of services provided to victims of interpersonal violence. And to this end, she led the creation of Nashville's 2 family justice centers, a court-based center called the Jean Crow Advocacy Center and a community-based center called the Family Safety Center. Both are award-winning national models for their size and scope of programming. While this is a huge accomplishment, Diane is far from finished as she continues to find new ways to make Nashville a safer city for the most vulnerable of us. Becky Owens-Bullard is the Senior Director of Programs for the Nashville Office of Family Safety, where she oversees the strategic work of all OFS programs and multidisciplinary response to high-risk domestic violence firearms disposition, human trafficking, strangulation, sexual assault, and fatality review. So she's a busy person. We're really glad that you took the time today to help us. Ms. Bullard is also a national speaker and consultant for the Department of Justice, Office of Victims of Crime, on multidisciplinary collaborations, leadership, interpersonal violence, and the intersections of human trafficking, domestic violence, and sexual violence. We also have with us today Frances Ho, who will be speaking to us today with expertise about the courts in California and the rare opportunity we have to support firearms relinquishment through a state grant authorized by AB 178. She will share information about the opportunities presented by this grant. Frances is an attorney for the Judicial Council of California, working on statewide domestic violence policies for the judicial branch. Before joining the council, Frances worked at the Superior Court of Solano, where she provided direct services to domestic violence victims and survivors. Working in the area of domestic violence has allowed Frances to appreciate the unique barriers victims and survivors encounter, including the effects that trauma can have on their ability to help seek, as well as the ripple effects on the individual, family members, and helpers. And we also have Marissa McKeon, a supervising deputy district attorney of Santa Clara County, who has been trailblazing on this issue in Santa Clara. She started in the Santa Clara office in 2006, has central felonies and general felonies before she was chosen to create and lead the office's Crime Strategies Unit in 2016. The Crime Strategies Unit is an intelligence-led policing and prosecution unit, and involves large-scale investigative projects with the county's police agencies. She has trained hundreds of police and prosecutors about gun violence restraining orders, including me. I was at one of those trainings. It was wonderful, thank you. And she is recognized and awarded by multiple law enforcement agencies for her work as a law enforcement liaison. Without further ado, Julia, if we could go to you, and you could tell us a little bit about SB 30 and its implementation opportunities and gaps that hopefully it will help heal.
Well, thank you, Paul. And I am very pleased to be here today. So I really want to welcome everyone. And during Domestic Violence Awareness Month, this is an opportunity, of course, for all of us to gather. And I'm happy to be here with all of these wonderful panelists. It's a chance for us to consider our accomplishments, some of which have been noted, and I'm looking forward to hearing more about it, and some I'm going to share with you. And also, think about the future, the gaps, some next steps that we need to take to reduce risks and increase safety. I'm also very well aware that we have in the audience, I always assume, given the prevalence of domestic violence and other forms of violence in our country, that we have many survivors with us today. And I just want to highlight that this is a very difficult topic, even when we are honoring and celebrating our accomplishments and learning about best practices, which of course always gives me a lot of hope. But this is not an easy topic. And I just want to recognize that. A little bit about why we're having this conversation, to put SB 320 and some of the other efforts in context. We know that a lot of people own guns in the United States. It crosses into our urban cores, our cities, as well as our rural communities across class and race. The pandemic, we've seen an increase in first-time gun purchases across the country. And we know that in the state, in California, over 14% of people personally own a gun. And an additional 3.1 million, over 11%, live in a home with someone else who owns a firearm. So we know there are a lot of firearms out there. We also know there are a lot of responsible gun owners. At Giffords, we work with gun owners who are invested in common sense gun laws. But in domestic violence cases, there is bipartisan support for policies that recognize the dangerous intersection of domestic violence and firearms. We know that this increases the risk of lethal outcomes, including what was shared at the top of this webinar, the situation in Sacramento County. There's a link to materials that I assume you will receive if you haven't received it yet. And I've included several different handouts in there, including an op-ed I wrote for the Sacramento Bee on that tragedy in Sacramento and the importance of looking at supervised visitation resources and more protective visitation approaches, given the prevalence and accessibility of guns, including unserialized parts or ghost guns, as they're referred to. So even when we prohibited that individual and prohibit others, they can too often obtain firearms without a background check too easily, including ghost guns. So we know that this is a lethal combination, firearms and domestic violence. We also know that there's over 1 million women alive today who have been shot or shot at by an intimate partner. So there are lethal outcomes, serious injury, and the trauma that goes along with that. We also know that this impacts the entire community. Over 2/3 of mass shootings include some kind of connection to domestic violence. So we're talking about Pulse, where there was a history of perpetration of domestic violence by that individual, that shooter. We're talking about actually murdering family members or injuring family members as part of an otherwise mass shooting that involves the public. And we know that there are times where people have become prohibited and there's been a failure to enter that prohibition in the database that would prevent someone from purchasing a firearm legally. For example, in the Sutherland Springs mass shooting at the church, where the military failed to enter that prohibition and the person legally purchased a firearm, even though they should have been a prohibited person. So we know there's a connection between domestic violence and mass shooting. So there are lots of reasons we want to be taking these prohibitions seriously. Now, California stands out as a state with multiple remedies in our policies for addressing the intersection of domestic violence and other forms of violence, not intimate partner violence only, but a variety of other forms of violence that we can take some kind of legal action around in both the civil and criminal contexts. You are probably familiar with the domestic violence restraining order that specifically addresses intimate partner and family relationships. All of those orders are firearm prohibiting at each stage of the process. We also have elder abuse restraining orders that are firearm prohibiting when dealing with violence. We have civil harassment orders that deal with strangers or neighbors or a stalking situation where there wasn't an intimate partner history. Those are firearm prohibiting orders as well. We have workplace violence prevention orders that can restrict an employee's access to the workplace and prevent abuse and harassment. Those are firearm prohibiting orders. And we have gun violence restraining orders. Those are the only orders that don't name a protected party or restrain anyone from coming onto a particular piece of property or address abuse or harassment. They're designed to reduce suicide and address mass shooting threats by removing firearms and ammunition. So we have a lot of tools to work with. We also have criminal restraining orders. We have mental health prohibitions if someone's admitted to a mental health facility. And you can learn more about these at our website, giffords.org, where we maintain a comprehensive nationwide database of all of the laws in the country related to firearms and firearm prohibition and relinquishment. So you can check that out. In the handouts that you'll receive, you'll see a chart that I've created that provides information that I hope is useful in safety planning, because it identifies the various civil restraining orders and their different characteristics. And it's designed to really paint a picture of the options folks have in these situations. You'll notice, of course, if you work with the restraining order forms, which I'm so pleased that Frances Ho is here. She's a leader in the state on making those forms up to date and accessible in plain English and in multiple languages. The Judicial Council forms include very specific information about firearms prohibitions. And here we're going to focus on the domestic violence prohibitions. And when I was at the Judicial Council, we worked hard on ensuring that that prohibition appeared on the form, not as a checkbox, because this is an automatic application of a policy. You are prohibited from having firearms and ammunition. That means that's what gets entered into the database, so that when a background check is run, you are prohibited from purchasing. That's what should come up. And you are required to relinquish any currently owned firearms within 24 hours and provide proof to the court within 48 hours. We have these policies in place because the research shows that they actually save lives. We see a 16% reduction in domestic violence related homicides when we have relinquishment procedures in place. And in California, relinquishment means it goes to a licensed gun dealer for storage or for sale, or it goes to law enforcement for storage, as long as the prohibition is in place. We don't transfer to family members or store in a safe when someone becomes prohibited, a safe at the house. When the prohibition is in effect, we're looking at relinquishment because of the level of protection it provides. Unfortunately, we know that implementation in this area in California, despite all these good policies, has not been as consistent as we would like to see. This is a picture of Callie Gray, who provided 12 pages of information about the abuse that she was experiencing, how frightened she was of the person, her ex, who had threatened her, including information about his access to firearms, including threats related to use of firearms. She provided that information as part of her restraining order request in Madera County. And unfortunately, despite that, the judicial officer indicated from the bench that he didn't see any evidence that there was concern about firearms. He still issued the restraining order and prohibited the restrained person from having access, but really diminished the significance of that prohibition in saying that. And she was tragically murdered in front of her children subsequent to that restraining order being put in place. Cal Matters did an extensive investigation, reporting, two-part series that was nominated for an ABA Media Award covering this issue. We know we can do better in California. And that's part of what influenced the work around SB 320. SB 320 went into effect January 1st of this year. Giffords was the sponsor of that bill, the only sponsor, under Senator Eggman's leadership. And myself and Allison Kephart at Weave, who's an attorney who works with survivors, and Senator Eggman's office worked on drafting that bill. We built it off of an existing rule of court that several of us had worked on at the Judicial Council. So much of SB 320 wasn't new or isn't new. It builds on existing law, but by moving it from a rule of court to a statute, we felt that it would elevate its importance, improve consistency, and we felt there were a few changes that needed to be made. Subsequent to that, we advocated for dollars to be put into implementation of SB 320 and civil firearm relinquishment generally, because that has never been adequately funded. That resulted in $40 million budget allocation in the state budget being included this year for the Judicial Council, which to me was very important, that the courts be at the table and be in a position to funnel money to law enforcement, to prosecutors, to focus on civil firearms relinquishment, including implementation of SB 320. And I think Francis is going to cover that in more detail. In terms of the specifics of SB 320, what I want to get into a bit, we only have a couple more minutes, but I want to highlight some key aspects of it. It certainly further reinforces the firearm prohibition in DVRO cases, which again is automatic. We know law enforcement has already been required to have protocols in place. They must remove those firearms they see in plain sight. They are supposed to be asking about firearms and retrieving those. When somebody is asked to turn over their firearms by law enforcement, they're supposed to be turning those firearms over upon request. If they don't, they'll have that 24 hours, if they're not asked, for example, or they don't have them with them or don't comply, 24 hours to turn them in, 48 hours to prove to the court. We thought it was imperative to add information about explaining how to do the relinquishment locally as part of SB 320. So we want this law to be implemented fairly and consistently. We know when we don't do that, we run up against concerns related to bias. Why is some person perceived as dangerous and someone else isn't? We need to be consistent across race, across class and geography, across judicial officers and law enforcement officers, so that everybody who has become prohibited, in fact, actually complies. So local information should be provided on that. There are other important aspects of it, including what I think is most significant here, which is that there are very specific consequences for violating the firearm prohibition in a domestic violence restraining order case that makes it very different from gun violence restraining orders and other orders that don't provide the kind of protection related to domestic violence that DVROs include. So the court is required to make certain findings. The court is required to figure out if the person has shown that they've complied or not when there's been a finding that there's a gun involved in the case. And the court is required to report violations to law enforcement and to the prosecuting attorney. And law enforcement is required to take immediate action. There can also be implications for child custody, and that's designed to deal with the kind of situation, the tragedy that we talked about earlier in Sacramento, and other very scary situations where children are directly impacted by the intersection of firearms and domestic violence. There's more information in those handouts that I talked about. I really also want to touch on this issue of why we have domestic violence specific orders versus a gun violence restraining order or red flag laws. This has come up recently, and I just want to touch on this idea that GVROs are really important tools. They are not specifically designed to deal with domestic violence. So there are some significant differences that I've highlighted that, again, I want to emphasize. There is an effort underway in the state to educate people about GVROs, because not as many household members or family members have pursued them. 96% of them have been pursued by law enforcement. I don't think that's a surprise. And I think we have to really deeply understand that we have a lot of remedies available to people when family members are concerned about abuse, harassment, or need other kinds of protections. So addressing mass shooting and suicide threats through a GVRO makes a lot of sense, but we need to be really thoughtful about when there's abuse and harassment, and expecting people to get 2 orders does not make any sense when we're talking about high-risk cases involving multiple visits to a courthouse. So let's be thoughtful about that. The last point I just want to make is how important it is that we be focusing on survivors and the impact that not implementing these laws has on adult survivors as well as children involved with these cases. This is a picture of Christy Camara and her son, Wylan Gomes. Her attorney, Joe Alioto Jr., just filed a lawsuit in San Francisco against the Department of Justice here in California to obtain the records on information related to a restraining order that had been issued by the court that included a firearm prohibition. Subsequent to that, during a supervised visit, Wyland's father shot and killed Wyland and shot and killed himself. And it appears he was able to purchase that firearm even though he was prohibited. So they're seeking information about how that transaction happened, where the gaps or the failing was in that process. There are, of course, real consequences here. And, my work is focused on implementation. The promising practices we're going to hear about today are possible. We've seen them in San Mateo County, which is taking a really comprehensive approach to firearms relinquishment procedures, and in Santa Clara County, where they have consistently been focused on the issues related to firearms relinquishment. So, and of course, Tennessee, we're looking forward to hearing about your good work too, but certainly in California, those are two excellent examples that I'm thrilled we'll hear from today. So thank you very much. And I know we have other folks to hear from, so I appreciate your attention.
Thank you, Julia. Much appreciated. I'm going to give our viewers just a chance to put in the Q&A if they have a question for Julia. You can put it in there, and we can ask her the question and see if she can answer anything. I'll give everybody about 30 seconds to do that. While we're doing that, though, I want to introduce again, Supervisor Don Horthley. I really do appreciate, Supervisor, you taking time out of your schedule for non-constituents but people that are really involved in the same movement that you've been a leader in San Mateo. Your perspective, being now Board of Supervisors, but also former sheriff, and we understand that you have really put together a program there that is really kind of a leader in California. If you could talk about, what it took to bring that together, who was necessary to have at the table, and how you were able to work together, we'd really appreciate it. Thank you.
Sure, Paul. It was good to hear from Julia Weber first. To some extent, just to give you a little background for myself, is that you indicated I used to be the sheriff. I was in law enforcement for, if I count all my departments, 39 years. But I spent 35 years in the sheriff's department. And at the beginning of my career, it was very rare to find people or suspects with guns. In fact, we used to see mostly just like a Saturday night specials. And by the time I ended my career about 2007, we were having to put M16s in our patrol cars just to be able to match some of the armaments that some of the people we were seeing on the street. So the proliferation of guns just simply got really way worse than when I first started my career. I don't think I ever, my first several years, I don't think I ever ran into somebody carrying a gun, except for maybe once or twice. But after that, it seemed like everybody seemed to have a gun somewhere. So in any case, when I was, we got a grant at some point in my career, probably about one of my last terms, about 3 years before I ended my term as sheriff. We got a grant from the Attorney General's office to create a domestic firearms compliance unit. And so we put together 2 detectives, and I think we had 1 detective from the Department of Justice. And then we basically enforced all DVROs. And in the 3-year period of time that we had that, we took over 400 firearms. And in one case, one person, we took 21 guns from one person. And I know that it prevented murders. I used to give commendations to my detectives, because I know that they would be chasing somebody down who had guns, who was chasing his either ex-wife or girlfriend. And I know that they were able to take guns away from that person and save the life. I just know that this is a kind of a program that will save lives. So in any case, I left the Sheriff's Department in 2007. Somehow over the years, that program just kind of got eroded away, probably because of other priorities. And I don't think there was much activity subsequent after my leaving. I was on a healthcare district for about 4 years. Then I ran for the board, and I've now been on a board of supervisor for 12 years. And every time we would hear about a mass shooting, especially in domestic violence and even in school shootings, we put together for school shootings, we created this thing called a Coalition for Safe Schools, where we would have, rapid intervention, training law enforcement differently. But every time we would see a mass shooting, I always talk about red flag laws. We need to do more with red flag laws. We need to beef them up. And we're not only that, we started looking at, one of my staff people did some research for me, and we worked with another supervisor, Dave Pine. His staff did additional research, and we kept on coming up with, there are red flags on the books, but there's not a lot of utilization for some reason. It seems that we had tools that were being underutilized. In any case, so we then, Supervisor Pine was working with Julia and the Gifford Center on gun dealer ordinance and a safe storage ordinance. And of course, they were doing gun buybacks, which I have my doubts about their effectiveness, but I think if nothing else, at least it dramatizes how many guns are hanging around in people's homes that are useless, and maybe it prevents a suicide or an accident. So in any case, because of all the work that Dave had been doing with me, we decided to do a seminar with the Griffith Law Center, and we brought the Attorney General and law enforcement folks, school folks, and started talking again about red flag laws and what's available to people for domestic violence and even for civil GVROs. And at the same time, we also knew about SB 320, and we invited the courts to be part of it as well. So at the end of the seminar, what we decided to put together, I, of course, went to the county manager. He's got all the bags of money, and I, of course, won them all. So we basically said, I want $1 million. I want to resurrect that firearms relinquishment unit, and I want to do more. And I want to work with the courts. Well, it's not just me, by the way, it's both myself and Dave Pine. And so we did put together some meetings. We, of course, involved Gifford Center and Julia. And so the program we've come up with is we have worked through the district attorney's office, not the sheriff this time. Sheriff was really short of staff. And while we would certainly like to get them involved in the future, they simply didn't have the personnel available. So we have the district attorney agreed to house 2 detectives, one from San Mateo Police and one from South San Francisco. And they will be a firearms compliance unit. Now every single police agency, there are 20 of which in the county, has agreed to cooperate. So if firearms are seized by the unit, they will agree to store them, because the sheriff didn't want to be stuck handling all the firearms from all those cities. And then for SB 320, the courts were certainly anxious to implement a SB 320. The problem is that they really didn't have, they feel like they're overburdened as it stands. So the county, we agreed to pay for a commissioner and as well as a paralegal. And it's not only for the implementation of SB 320, it's also we wanted the general public or police agencies or a victim of domestic violence to have some help about getting a GVRO or a DVRO. So there's our courts then have a family law center. They have people there already, but it's going to be completely beefed up with a separate commissioner to handle all those cases, as well as staff to help people walk them through the process of being able to obtain a GVRO or a DVRO. And then we have the enforcement arm, and it has just started. In fact, I think we've had a press conference the other day. I was looking at my staff person to figure out, I got so many different things that happened and that I got confused. What did I do yesterday? But in any case, we had a press conference about it. And I think it's going to be, I'm really hopeful that it would be really successful. And my argument always has been that, we may not be able to do much in terms of gun sales and gun purchases and, with the Second Amendment people, but there are things that we can do, taking guns out of the hands of people who shouldn't have guns. And one of the programs that I didn't mention is also a state armed and prohibited list that has something in the neighborhood of a couple hundred people in the state who have arms and are prohibited. So we will also enforce those requirements and those actions also in the county. Now, people have said to us, how can you just kick somebody's door down? Not exactly, you can't do that, but you can get, yes, you would know, Paul, you can get an arrest warrant or search warrant, that is, to go into a home if they refuse to cooperate. So we're pretty hopeful that we put together a pretty comprehensive program between the courts, the district attorney's office, local police agencies, the sheriff's department, and probation to utilize all the tools that are available to us, and specifically those red flag laws that I think have been underutilized. And so that is a pretty quick synopsis of our program.
Hey, Supervisor, I would love to know who in the court system did you bring in for meetings, and who at the district attorney's office and law enforcement?
The district attorney himself was involved, Steve Wagstaff, and the judge, it was one of our Superior Court judges, Judge Greenberg. She actually participated in the seminar with the Gifford Center, and she's been the lead in bringing this to fruition. She will not be the commissioner, but there will be a specific commissioner, and they will not change. For example, they won't, you won't go shopping at different commissioners. One commissioner will handle all of those cases for the county, so that there isn't, a confusion or essentially judge shopping, or maybe somebody doesn't understand the protocol as well as others. And so we, I think that makes it much more coherent.
I'm impressed by that, because I know my wife is a retired Superior Court judge. And when you first become a judge, there's no specific training for all judges on this issue. And yet the beginning judges were often put in family court and asked to make those decisions, which can cause not just safety issues, but frustration for everybody that ever, is involved in the process. So I'm glad to hear that there's specific training and a specific judge who's been trained on the issue.
And it will not be the newest commissioner. There's a commissioner who has experience, and that commissioner will be the sole person handling all the GVROs and DVROs, as well as SB 320 implementation.
That's fantastic. Well, thank you. Much appreciated. We do have a few questions in the question and answer. I think the first one probably, I don't know if it would go to Julia or to the supervisor, but it talks about gun restrictions on DVROs and CPOs are for registered guns. Any guidance on how to handle firearms that are not registered?
And I'm happy to jump in here, Paul. And of course, Supervisor Horsley, if you want to add anything, but that is not true. The prohibition is on firearms and ammunition, registered, unregistered. It is a prohibition on both. Certainly, the court is required to run a check under the automated firearm system, or AFS, and what's going to be in there are registered guns. But if a person who's asking for a restraining order describes or mentions other types of firearms, those are part of the prohibition. If they don't mention them, they're still part of the prohibition. And specifically as of July 1st, unserialized parts or ghost guns has been baked into the definition of firearms that are prohibited in domestic violence restraining order cases. So those are prohibited, in fact. And there are multiple ways they can be identified. That is through the declaration, through testimony, and through additional ways of providing evidence, as we do in all cases. So I think that's a really important part of it. And there were a couple of other questions related to how you get this going that I think hopefully we'll have some time at the end to go into more detail. But because Supervisor Horsley, you've shared this information, I'll just point out that I worked very closely with San Mateo on getting the courts involved. And as I said in my presentation, to me, having the courts at the table is critical. They often aren't, because we don't always do a good job of figuring out how they can be included. We have to respect neutrality and the various requirements that judicial officers have. We can also work with court administrators. But San Mateo had a supervising family law judge, Judge Greenberg, who stepped up, who had a background in criminal procedures, who was very interested in ensuring that this law was being followed. We at Giffords supported the convening that we co-hosted. You had the Board of Supervisors leadership that was critical, stepped up, said, we want to make a difference here. So not everybody has all of those players in place at the outset, but there are ways we can work with your community to support a convening, to support behind the scenes meetings if necessary, and to work with the Judicial Council to provide judicial education and to get your court leadership involved, as well as law enforcement, prosecutors. I mean, you have some of the best people here in the state on this panel in terms of the DA and the DA's office, policymakers, folks in the Family Justice Center movement. But we can identify key leaders and bring folks together to make this happen. So reach out, let us know how we can help, and we can develop a strategy for your community in particular.
Okay. The final question is, how do you ensure that Superior Courts and the system that's connected to it, obviously with law enforcement, complies with SB 320? And what would happen if either a court or law enforcement or another partner did not comply?
Well, the other piece that I noted in my presentation that I'll further emphasize here is the use of the media. There are various ways to hold our policymakers and our systems accountable, telling the stories, requiring reports at open meetings, appealing cases. There are various strategies. So, it again takes a specific group of folks understanding what's expected, giving everyone a chance to do the right thing, and then leveraging our appellate processes, our media, our election procedures, and holding everyone accountable. It's tough to hold individuals accountable to firearms prohibitions if we're not, as a system, being accountable to survivors and being accountable to the laws we pass. So I think there are multiple ways to proceed with accountability that we can go into if we have time at the end, or we can follow up on, because I don't want to take up too much time from others.
Can I just add that we have added performance measures to all aspects and all elements of our plan. So I think we'll have a pretty good handle on the compliance.
That sounds like it would be a critical piece to make sure that whatever is implemented is actually producing what was hoped.
That's part and parcel of the agreement between the courts, the county, and the law enforcement agencies.
And when San Mateo did that years ago, the numbers were remarkable and hugely important in shaping what resulted in SB 320 this many years later, documenting how many guns they were able to obtain through the program that Supervisor Horsley mentioned. So that's absolutely critical. And we've seen the results of documenting the firearms that are obtained through those processes.
Fantastic. Thank you. Okay, I think it's time to move on to Nashville. We have Diane Lance and Becky Owens-Bullard from Nashville. If you, the two of you could talk to us about your program, where you started, who you brought together, and what you were able to accomplish.
Great. Thanks, Paul. And I think I'll start it off, and then Becky, who has done so much of this work in her area in our office, will finish this up. So we really appreciate coming from Tennessee, the opportunity to speak to a California audience. I lived in California out of college. I love San Diego especially, and so it always feels like home to me. Your laws in California and your resources, I mean, just listening to what we've heard in the presentation so far, hold a lot for us here in Tennessee, in a really strong red state, to be really envious of. So, we go to our legislature and we hear, well, why don't we just arm the victims, So, we say, oh, California's doing this. And then they're like, oh, California, we need to go far the opposite way. So we have a really hard time in Tennessee. And so we're here to tell you how to work with what you have while you're trying to move things forward. So, really because of what our laws lack, we here in Nashville have had to be, they were called the blue dot in Tennessee. We've had to be really creative to ensure that the laws that we do have are being followed and they're being enforced. It's exactly what Julia just said about holding the system accountable for the laws that do exist. So that's what you're going to be hearing a lot from us today about how to even just do that and understand how we have a voice in order to hold our system accountable, how to hold our judges accountable in our court system and aspects of our law enforcement accountable for the laws that exist. You need to sort of understand who we are in our larger government. So on the next slide, you'll see, we're the Office of Family Safety, and we're that yellow square. We are a department within our metro government. And we, as the department head, I report to the mayor. And so we have a very standalone voice when it comes to interpersonal violence and the things that are making our community less safe, especially for women and children, and especially in regard to firearms. So as part of our department's work, we manage both of our family justice centers. This slide shows you our community-based family justice center. You can see the overall building on the top left and sort of a flavor of what it looks like on the top right. Just like California, we have a statewide family justice center initiative. I think California has the most family justice centers in the country, which is wonderful. I love that. And Tennessee, our state, we have the most per capita. So we're both doing good work and heading in great directions. So I think there's a lot to be proud of. Our second family justice center, which my department, we have 43 people in our department. The second family justice center that we manage is in our courthouse. And I just want to show this slide for anyone that has extra space in their courthouse. We took 3,000 square feet in a connected building and made what we call the Gene Croazzi Center. So victims in our courthouse come here for help instead of going to the courtroom. But I know that's not why we're invited to talk. I did want to make sure you all understood a little bit about where we are coming from as part of our government. But in terms of our firearms issue, it starts exactly how, this conversation began when we started the webinar, is talking about women murdered by men. And Tennessee has been in the top 10 for 20 out of 25 years in the country. This past year, we escaped the top 10, but, not to overachieve, we were at 11. So it's something that is a continual problem, a continual concern. And a lot of these homicides are firearms are used in those homicides. So as part of Tennessee, these are dismal numbers of a top 10 list that we consistently rank within. So what we did is we sort of looked at, and this is Nashville-Davidson County, we looked at firearm dispossession as being a priority for our department when we saw what our 2018 to 2020 numbers looked like. 36% of domestic violence killers, so those that killed, in their family, those living in the same home, and certainly intimate partners, used a firearm that they should not have had under our laws due to their past domestic violence conviction, a granted order of protection, or a felony conviction. So that's not even looking at all homicides that shouldn't have been convicted, shouldn't have been committed with a firearm because they should have been dispossessed of that firearm. That's just looking at the domestic violence ones. So, similarly, on the next slide to what Joyce said in her intro, we also looked, I think, Joyce, you said that you all looked at your danger assessment. This slide shows us about our lethality assessment protocol that police do. In 2021, 49% of victims who were given the LAP reported that their abuser had or could easily get a firearm. That number went up by 8% from the year prior. I mean, all of our numbers, the homicides, everything have gone up since last year. The next, at 37% of lethality LAP victims reported that their abuser had used or threatened them with a weapon previously. And that is up 4% from the year before. And then 7 out of our 11 domestic violence homicides were perpetrated with a firearm. So trying to do something about this lands squarely into our high risk work as a department. So going into sort of what our laws are different. And again, as I said, we have a lot to be envious of. So I know you're frustrated and you want improvement and you want more, but we listen and we see a lot that you do have. So in Tennessee, this is what we're operating under. Anyone who's ever been convicted of a felony or a DV misdemeanor, actually, I'm not just going to read through all this, but you can sort of see what our laws and go on to the next slide, Becky, and you'll see where the real differences are. So you all in California, you have restrictions when there's just a restraining order. It's so much broader with domestic violence and police harassment schools, whereas we do not have that. It's your classic order of protection, an intimate partner, domestic violence type of situation. You have dispossession required immediately upon the granting of an ex parte order of protection before the actual hearing. We do not. You have to wait within 48 hours of the actual hearing, and it has to be a permanent order of protection granted against them. And then you all have dispossession to law enforcement or a gun dealer, and we have third-party dispossession. Which is not a great thing, and with very little follow-up on that. And then we have no way to really, our whole accountability system is very poor. And this, you can sort of see on here what the differences are. So again, we look at it with some as being sort of an enviable position that you are in. But one of the things that's the hardest that we rely on, that we have fought the hardest against, is that we have to rely on an honor system regarding if someone is continuing to possess a firearm. So again, this sort of summarizes what we have: no legislative compliance hearings to make sure the person is dispossessed. We trust the offender that when they say they sign an affidavit that they don't have a gun, we trust when they sign it that, oh, I had a gun, but I've given it to a third party, and we don't have any way to follow up on that. That's required by our court system. So there's no legislative compliance hearings. So if you pull back the cover on that a little bit more, it means that third parties, we've had some homicides in the past where someone has said they've given the gun to the uncle. Maybe they did give it to the uncle, but the uncle gives it right back to them. So there's just no follow through. So what you have to do is you really have to be aware if they have another gun charge come up, or if a probation checks and makes sure there isn't a firearm there. So we are the only state that in the whole country that doesn't require abusers to have any information about the third party to provide anything to the court system. So why am I talking about like all the things we don't have while you all were talking about the things that you do have? I just want to describe it to you because our firearms work works within a very challenging environment that despite that challenging environment and with very few tools to work with, Becky, who will speak to you next, has done just an outstanding job to work on making progress in the accountability of making sure we follow our firearms dispossession laws. And it has been really patient work. It is like trying to make a gourmet meal out of a very bare cupboard. She does this while she works on all of her high-risk work. And as I said, we consider our firearm dispossession work to be part of all of our high-risk work. And so we're trying to tackle all of these issues you see on your screen along with our firearm dispossession work. So Becky, I'm going to pass it on to your more graceful hands than mine to finish up describing what we have going on.
I don't know that that's the case, but I will give it a go. So thank you all again for having us. And it's so great to be here with so many experts in the field on firearms dispossession. And we'll just walk through what our process looked like. And as Diane highlighted, we are in a very challenging environment for our firearms dispossession work. And before we get into kind of our timeline, these are the task force members that we bring together on our firearms dispossession work. As you can see, some of the things that were mentioned previously about making sure that judges are present and a part of this work is certainly something that we have been grateful to have from our jurisdiction. Our judges are heavily involved, as well as our Attorney General's office, the District Attorney's office, our court clerks, probation, both our general sessions and state probation, our mayor's office, as Diane mentioned, that we work under, our police, and our sheriff's department. So we really started from a safety and accountability audit that Diane led that was published in 2013 that really moved through our entire criminal justice system to see the gaps that we had in providing safety and accountability, and particular on domestic violence. And what was highlighted around firearms dispossession was that it was inconsistent or not happening really at all in all parts of our criminal justice system. So from that 911 call all the way to the disposition of a case and probation. So what we did, I was hired under an ICJR grant, and I was able to work on all of our high risk programming. And where we started with firearms was to kind of go back to that assessment and see where we were at and what our procedures look like on firearms dispossession. And we found much of the same. So post our big safety and accountability assessment release, we still saw inconsistencies in dispossession in the courtrooms, from the DAs, from police. So we knew that there was a reason to kind of bring everyone together. And that was an important piece of buy-in. So for those of you who are trying to bring people to the table, a good way to start with that is to show that there's a gap. And this is a great way to do that. We then looked together at best practices. And I just want to shout out San Mateo here. I certainly looked at best practices from your county and pulled from that for our firearms dispossession protocol. And we looked at, we spoke with different experts around the country about what was working and what wasn't, and talked with our committee members about what we thought could work in Nashville. We also attempted the legislature. It did not work out very well, which Diane will talk about in a little bit, but we did attempt to try to put some kind of parameters around the third party, and that failed pretty spectacularly in 2019. So we knew legislation was not going to be the way that we could go. So instead, we started to flag through our office all firearms cases that were going to be on the dockets for orders of protection and for our criminal misdemeanor cases. We brought in the National Resource Center on Domestic Violence and Firearms to talk with our team. A lot of times they would throw up different barriers and walls, and this expertise is really helpful in getting them to hear not from just Diane and I about why we could move forward, but from national experts that could tell our team about best practices around the country. We then had our judges agree almost right before COVID was upon us that they would hold compliance hearings. That, of course, fell to the wayside with the increases in issues in the court system with COVID-19 pandemic. And then we readdressed this in 2020. So we're now holding compliance hearings. So we made sure to draft out every single step of our protocol. So that way there was no question about who should be doing what on firearms from the beginning of the time that we could identify those until the end. Our firearms flagging that I mentioned, this is what this looks like. We go through every single case in our office. This is a lot of person power to put behind this effort, but we think it's really important. This way, there's no way that someone can say we didn't know that there was evidence of a firearm when that person is making the argument that they don't have a firearm. This is your proof. We found it on the lap. We found it in the order of protection. We found it in previous criminal records. We found it from a discussion of our high-risk team. We also decided to flag stranglers here as well because we know about the risk of both. And if we're looking through this, we want to make sure we're flagging both. So when we started this process, we saw an enormous amount of respondents and defendants with evidence of firearms and evidence of strangulation. We also consistently flag this on our high-risk team. So our high-risk cases are obviously the highest of high risk. They come from our LAP and our danger assessment. And we see over 80% have some firearm access or use within their review. We also pulled from a best practice around firearms identification. So in our 2 family justice centers, our advocates can talk with a client who says that their offender has a firearm. They can go through pictures and identify what the firearm looks like, where it's kept, any social media pictures there might be of this firearm. So this just gives additional information that with the release, we can pass along to ATF, the AG's office, the district attorney's office, and police. When our judges told us that it's hard to keep up with all the different things in the courtroom and what process they needed to follow under our state and federal laws for firearms dispossession, we created a very simple step-by-step bench card. That way they could go through the law, they could know the reference and know what they needed to do next in the process. When our police said that they oftentimes forget that they have to seize firearms during the commission of a DV incident, or they don't utilize the may seize firearms in plain view, we said, we'll make a pocket card for that. So make sure that they have every tool in their toolbox that they can use on the scene and in their investigations. When we talk about respondents and defendants not understanding that they have to dispossess, that was mentioned previously, we have a brochure that they can utilize so they know their responsibility to dispossess, as well as one for our petitioners for orders of protection and victims of domestic violence crimes. Our clients also are able to walk through a firearm safety plan, and we also have a really nice video that talks about high-risk indicators that explains everything from firearms to strangulation and stalking and why these are very risky behaviors for an abuser to be partaking in. So those are some of the things that we created to fill that gap when we kept getting barriers. And then Diane's going to close us out with a couple of barriers that we still continue to encounter. Oh, you're muted, Diane.
All right. So we've got, as Becky said, we have some protocol barriers that we're still working through. We have compliance hearings that, that took a lot of work to get the judges to do that. We had to get our Metro legal team involved to make sure the judges knew that they are allowed to do that, and making sure the clerk's offices assist in that as well. Some barriers to our protocol was saying that, there isn't room to store it. We had one police chief say, oh, I can, and the next one saying, oh, I can't. So you had those things happen as well. Fortunately, you do have the gun dealers as an option and some other opportunities, but, we would certainly prefer that firearm storage and gun dispossession would happen to law enforcement. And then identification of firearms and search warrants and getting that to be more robust with our officers and going for those search warrants when we know that when the evidence indicates that this offender is still in possession of a firearm. So that is a lot of reminding in a lot of these things, is making sure, as Becky said a bunch of times, making sure that cases don't fall through the cracks, making sure the system remembers that there's legal liabilities here with missing a case where it's very clear an offender is not supposed to possess a firearm continues to. So one of the things that we do is, there was this enormous gap that no one was paying attention to, which is simply that offenders were not turning in their firearm dispossession affidavit. That is a form that they sign saying, I have dispossessed of my gun, and they sign that they did it. And they have to turn that in within 48 hours of the OP or the domestic violence conviction. And again, it's an honor system, so it doesn't have a lot of teeth, but at a minimum, we thought it was very important that the law is complied with. So we could sit back and say, oh, it's an honor system, it's just a piece of paper, it doesn't matter. But we have worked really hard over the past year to assert that it does matter. It matters that we follow the law, because if we let up on that, goodness knows what else we're going to let up on. And at a minimum, it has a lot of legal vulnerability in there. So every single week, we send to all the judges and clerks, to their elected officials or their leaders, which defendants or order of protection respondents have not turned in their dispossession firearms paperwork affidavit. And so what's boxed there at the bottom is an example of one part of that email, that it's a non-compliance notification. We give them the case number, the case name. We mentioned that the declaration form was mailed by the clerk on this date and that the respondent failed to return the form as mandated. So there's a list every week. And I'll tell you, the first time we sent this out, I mean, I got some calls from judges who were really unhappy that this came through on their emails right before an election season. So, but within a couple of weeks, that list got a lot shorter, and so it's at least making difference in compliance. With the next slide shows that we also send a broader list that includes the assistant district attorneys, ATF, and the AGs. So that email includes everything that the judges and the clerks get, but also those where we suspect there's non-compliance. And so that might say something, if you look at the box at the bottom, that the declaration form was completed, meaning they turned in and signed that they don't have a firearm and they claim no gun, but there was a gun indicated in the OP narrative and that he had threatened the petitioner with the gun. Or we can say there, was an arrest since where that has happened. So that is what we're sending every week in an effort to increase the accountability to the firearm dispossession laws, that they're being followed. Becky, I'm going to let you take this, if you don't mind.
Yeah, and then our final thing is just to say that, we have seen a lot of great outcomes from this, just removing barriers, pushing those practices like Diane said. And we did want to bring up that we did have one negative outcome where the courts decided they wanted to make a process by which the petitioner for the order of protection had to file a motion when the form was incomplete. So putting the onus back on the victim to file their form. We've since had some changes with that courtroom, and we're hopeful that will be done away with, that new process will no longer exist. But just a reminder that you can have positive outcomes and also sometimes have some negative outcomes. When we pushed that legislation I mentioned, we had a little bit of negative outcome with the NRA really honing in on all of our firearms laws and looking at dismantling those even further. So we keep forging ahead, but it's a good reminder that you kind of never know where things might go as well. So that is. Go ahead, Diane.
Yeah, that's such a good point, is always making sure when you take that step forward, who's going to be there, and try to bring it backwards in time. And any, it used to be when you had firearms dispossession, when you had firearms legislation, when it involved domestic violence, all was good in the law and order legislatures were for it. But the NRA now shows up at anything that we put forth that involves firearms. And it's, it got to the point where I stood to testify on this, and I think over half of them just got up and took a break. It was the oddest thing. So always be careful about that.
All right. Thank you both for really outlining what it took to get movement in a, as you say, a state that is not necessarily pro-gun legislation. I also want to say that one of the luxuries you have, I think, in Nashville is you don't have to deal with what Supervisor Horsley just had to deal with. Apparently there was a 5.1 earthquake in San Mateo. So he had to leave us, unfortunately. He won't be available for questions afterwards, but we thank him for his time as we thank you. Let's move on to Francis Ho, attorney with the Judicial Council of California, talk about AB 178 and the potential grant program that is upcoming.
Great. Thank you, Paul. And I think my slides are with the network. If somebody could cue those up, that would be great. But while we're waiting for that, I'm Frances. I'm with the Judicial Council. And for those of you unfamiliar with our work, something that we work on that probably touches your work is that we update and create judicial council forms and rules of court. I work on domestic violence restraining order forms. If you ever have any issues or questions about those, feel free to reach out to me. I love geeking out on forms. That is not why I'm here today. I'm here to talk about something I'm not used to talking about, which is we have additional money. Thanks to the advocacy of people like Julia Weber and others, Assembly Bill 178 allocated $40 million to the Judicial Council to start a firearms relinquishment grant. It is one-time money that was given to us at the beginning of this fiscal year in July, and is going to be distributed through a grant application process. And the deadline was actually last Friday, so we're in the review stage. And we hope to get the money out as quickly as we can. And the goal really is to ensure that those who are court ordered to not have firearms or those parts or ammunition properly relinquish them. And priority is given to relinquishment in civil court cases. And as others have talked about, how important that is in domestic violence restraining order cases, where we know the presence of a firearm really increases that risk of harm or homicide to the victim or survivor or family members, and also because of the connection between domestic violence and mass shootings. Next slide, please. So as I mentioned, it is one-time funding available for 3 years, but it does take a few months to kind of start a new program, get out the application and run it through our approval process. And so the goal is to have a recommendation for who should be funded by January of 2023. It would go to the Judicial Council for their approval, and money would be made available by February 1 of 2023 through June 30th of 2025. Any funding that we do not use will revert back to the general fund. All superior courts were eligible to apply. One requirement was that they at least say that they would contract with one law enforcement agency, and the law enforcement agency or agencies would get at least 30% of the total funding that they were asking for. Courts also had to essentially explain the new or expanded program that they were going to create with this fund. So for example, with a county like San Mateo, who already has a robust program, they would, if they applied, they would be able to expand that existing program. The grant funds would not be used essentially to supplant what they already had planned. Next slide, please. So to give you an example of just some activities that could be funded under the grant, here are a few examples. It's not an exhaustive list, but completing forms. It could be the domestic violence restraining order form, response forms, that proof of relinquishment form that other people have talked about. And so important is that order after hearing, right? Or a continuance form to make sure that those firearm prohibitions get into all the law enforcement databases, whether that be the CLETS database or the California Court Protective Order Registry that the Judicial Council maintains. The court could use the money to have regular compliance review hearings. We know how important that can be, as Julia talked about, you know, the success of having regular compliance hearings. Local and regional coordination. So that's just coordinating, right, with all law enforcement agencies, which can be dozens if you're, you know, if you're in a county of mid to large size. Training within your court, and also maybe with law enforcement, and you know, any aspect of implementing Senate Bill 320, like creating local protocols or information about relinquishment, right? And we've already heard about some possible issues with storage, whether law enforcement has the capacity or space to store ammunition, which is a new requirement, right, under SB 320, that in a domestic violence restraining order that the restrained person surrender their ammunition in addition to those firearms or firearm parts. And Becky also talked just about the people power that it takes to review files. And so that's certainly something that the court could use the funding for, to have a dedicated person or persons to go through all the court papers in a file or files. And next slide, please. Here are some examples of law enforcement activities that could be funded under the grant. So serving court orders. Typically in California, if you want your domestic violence or restraining order served, it's by law enforcement. It would be the sheriff or marshal in 2 of our counties, but it could be other law enforcement agencies that serve, right? And so their time could be charged the grant if it's a new duty. Investigating, obviously, if the restrained person may have any prohibited items. Facilitating compliance, having that conversation with the restrained person, making sure that they know how to properly relinquish by selling or storing with a licensed gun dealer, or storing with law enforcement, or turning it over. Sometimes it's for destruction. Updating data systems like the automated firearm system, and making sure apps, I forget what that stands for, Julia does, but if you're a prohibited person, prohibited from having any firearms, you're going to be in that DOJ database, and making sure that that information is correct. Local and regional coordination. And this is really where, this goes to, I think, what the network could be working on is people have already talked about, having those relationships with the court, and making sure that the court is connected with domestic violence and community-based agencies to talk about safety, right? Any protocol for firearms relinquishment really needs to, number one, take into consideration the safety of victims, survivors, and families who are going to feel the impact of, any investigation of whether the restrained person has firearms. So making sure you're at the table when those policies and protocols are made. And training and outreach, that could be training within law enforcement, within an agency itself, but also training other law enforcement agencies in the jurisdiction or regionally. And of course, law enforcement also has a piece in implementing Senate Bill 320, which is if the court is sending a notice of non-compliance to the law enforcement agency after a restrained person has failed to comply with the firearms relinquishment order, that law enforcement act immediately on that order. Next slide, please. One-time funding often comes with an evaluation piece because the legislature wants to know if the program is working, right? And so all of our grantees will be required to submit data. Here are some data points that are listed under AB 178 that would be required. The Judicial Council will also be responsible for partnering with a research entity like the UC Davis Firearms Violence Research Center, that entity or another like entity, to see if this program is working. And if it is, hopefully that would mean additional funding and investment from the state legislature. Next slide, please. I think that's it for me. I'm happy to answer any questions. Like I mentioned, the deadline was last Friday, but if there is an additional opportunity for courts and communities to apply for the funding, I will be sure to send it to the network so that you're aware that your community might have the opportunity again to apply for this funding.
Okay, thank you, Frances. I really appreciate that grant required the kind of coordination and bringing together of system partners to make it work. I also want to do a shout out to Marissa, who's been sitting there in Santa Clara, who also apparently felt that earthquake and yet is hanging tough with us to give her presentation. So thank you so much.
It was quite the drama here in San Jose.
Oh my gosh. Okay, so I'll just stop talking and let you go.
Thank you, Paul, and thank you for having me on this very important panel. I have the great privilege of bringing up the rear and kind of summarizing some of the issues based on my experience in Santa Clara County. So I'm very lucky to practice in a county where we have a long, rich tradition of really prioritizing domestic violence, lifting up survivor voices, and having comprehensive relationships between our courts, law enforcement, community partners, and the district attorney's office. So it is in that tradition that my unit was born. I run a crime strategies unit where I am the law enforcement liaison unit for the county. And from that position, have had to tackle basically our number one priority in every sphere, not just in domestic violence, has surrounded firearms policy, and implementation of different firearms laws. And it's very challenging. I will say that there are certain things that we've experienced here that I know will resonate across the state. I've seen some in the questions that have come from our listeners. And I will say that the challenges are that in many instances, when you're dealing with relinquishment issues, so in our county, for example, we know about failures to comply with judicial orders because our judges have been leaders in training on holding compliance hearings and relinquishment hearings in family court, civil court, and also in criminal court. So our procedure in Santa Clara County is that in all criminal and civil matters where there is a new firearms prohibiting event, meaning in criminal court, we're at an arraignment and now you're going to get a criminal protective order and you're being served with your criminal protective order, and that includes a firearms prohibition. They are immediately asked whether or not they have firearms. We at the district attorney's office run out all of our defendants to see if they have registered firearms, and then the court holds an immediate compliance hearing. That's in criminal court. It's very similar in civil court. In family court, in all of these hearings, we have judges who are asking whether or not there are not just registered firearms, and this is a question that was in the chat, and I really want to address it here. The prohibition on firearms and ammunition is not just for registered firearms, and in fact, the majority of the crimes that we see at the Crime Strategies Unit, almost entirely our shootings, both fatal and non-fatal, are often occurring with unregistered firearms, either because they're unserialized ghost guns or because they're using a gun that is stolen, bought by a straw purchaser, et cetera. So this prohibition from restraining orders or criminal convictions applies not just to registered firearms, but also unregistered ones. So the thing we really encourage our courts and also our partners to think about is we're not just caring about guns that happen to make it to Department of Justice as registered, but look for all evidence of a firearm in the presence of a domestic violence relationship. And this is the point when I really want to underscore, and I know everyone on this call would agree, that really the core component of all of our work should be focused on survivor voices in this regard. Survivor voices in police reports, in court, in restraining order documents. Tragically, Julia showed an example in her talk of very extensive survivor documentation of firearms that were present in her life. These are the things that judges, law enforcement, advocates, community justice center workers really have the ability to create avenues to be asking these questions where we get good answers. I love the forms that are being used by Nashville and King County and Washington and other jurisdictions soon coming to Santa Clara County that make it easy for survivors to recognize firearms. They have pictures of a firearm and they ask, do you have one of these in your house? And then it makes it easier to prompt some of these responses. These are difficult things to ask. They're often, there's going to be a variety of interactions, both in and outside of a courtroom, that could lead to good responses. But then when we have this information, I think everything that we've been saying here today, we have to have a process that honors that response. And by far the hardest piece of the puzzle is getting hands on guns that are inside of houses. And one of the questions in the chat hits the nail right on the head, which is, what do I do when now we have a compliance check from court? They've said, hey, we have a finding of non-compliance. We have evidence of a gun and it's a prohibited person. How do I get a cop to go into this house when they think it's just a misdemeanor and they don't want to have civil liability? This is the hard challenge. So in Santa Clara, I have two pieces of advice. They're both, I think, very important. My first piece of advice is implementation begins with education. So implementation, which is super important. I love that that's Julia's full-time job. It is crucial. it brings laws to life, but it begins with education. You have to educate your law enforcement partners about safe and responsible ways to do this, beginning with, this is literally your job. This is your job. And then secondarily, here's how they do it in other jurisdictions. So there's a variety of approaches. First of all, in some instances, I think the question in the chat was, well, what if it's a misdemeanor 166 or 273.6? First of all, there are, as Julia has pointed out, in Penal Code 1524, there are a variety of justifications to obtain a search warrant, even for misdemeanor violations. So 1524A 9, 10, 11, and 14 all address various different things. However, you might also have a felony. So again, back to survivor voices. If you have evidence that a prohibited firearm has been used out in public, was loaded or concealed, you may have a felony. So if you don't know, there are a variety of places on the internet you can find this. You can work with your prosecutor's office to help you figure this out. But the answer is not, oh, it's hard, so I'm not going to go do it. So our education is we train law enforcement officers to get guns early and to do it in the context of a hot call, preferably. And what I mean by that is when they are at the scene of an initial domestic violence, making it part of your departmental policy that requires you to try to get your hands on firearms. So we do that in our training. We do that by purpose. And that's because we know as you move away from that original incident where the suspect was maybe in handcuffs or maybe not at the home, but law enforcement was already engaged and able to get the firearms, it's increasingly difficult from that day forward. But let's say now it's 2 weeks later, we have a finding of noncompliance. I highly encourage officers to work with people such as the Department of Justice Bureau of Firearms in these instances. They have units that are specially trained to go in and get their hands on people who are armed and prohibited, and they do it in a thoughtful and meaningful way. And they have great training for local law enforcement. Or you can contact one of us who are on this call, including myself. I'll make myself available to talk about how we've encouraged and trained our officers. But let me say this, because I know we have very few minutes and I'm eating into our question time. Really, you need a champion. You need a champion at each police department who makes it their personal responsibility to find a way. Police officers, for good reason, are very nervous to go in and re-engage with people who are potentially armed and dangerous. And that's for good reason, and it's based on real experiences. However, if we don't get our hands around this issue and really have a different approach universally between prosecutors, courts, domestic violence advocates, and specifically the police who have to go do this work, then nobody's going to do it. And they're not doing it. And so what we've had to do in our county is to create a specialized team. Literally this year, for the first time, we've had to say to our board of supervisors, if you don't fund a team whose full-time job it is to go get your hands on guns, people aren't going to do it. And this is just the reality of how difficult it is for police in 2022 and beyond to interface with these omnipresent issues. So we created a dedicated team to do this, and they are going to have to deploy the kinds of practices that other units around the country are using, such as in King County, as I referenced before, or in our county, or with Bureau of Firearms for a warm engagement. But you do need an advocate. So my 3 Ps that I will leave you with, the first thing that you need in order to be successful in this field is passion. You have everybody who's sat through this, all 81 of you who are still with us. I know you've already got it, or you wouldn't have bothered to listen this long. I know you believe in the urgency of this mission. The second is partnership. You have to have willing people within the police departments that you work with who understand the urgency of this issue and find their way to yes. There's 2 kinds of people. I don't care if you work at Starbucks, the DA's office, or San Jose Police Department. There's people who find their way to yes and people who find their way to no. Find the yes people. Make them your sidekick, and help find a way where you can write internal department protocol that allows you to engage in certain types of calls. And you can absolutely do that. And then finally, so passion, partnership, and the final P is perseverance. This is a career-long thing that you're taking on here. And these are difficult issues, but what we can't do is give up. So there are people around the country who have tried things. You're going to become one of them. All 80 of you who are left, become an advocate, become the voice. You have the power to change minds and hearts. You can do it one person at a time. So find your champion, be a champion, work within the laws. And if you have questions, I know the people on this presentation will answer them for you. We're in it to win it in this space because we don't have the choice not to be. It's too important. So California law is great for you. There's tons of things you can do, but implementation starts with training, and it ends with you implementing it. So I know that I started late. I tried to keep it short, Paul, but we still have a few minutes for questions and to wrap it up.
Okay, thank you. If there are any more questions from the people who have survived the earthquake and still are on our call and are willing to do a question, please put it in the Q&A right now. I think we've already answered the ones that are in there. What I do want to say, I want to tap into Marissa a little bit. For those of you that have been involved in the Family Justice Center movement, you have all faced what Marissa has talked about, where there are going to be people that aren't getting it, that don't want to do an extra step or an extra 2 steps or an extra 20 steps or whatever it's going to take to make something important a reality. So I would say to everyone that's still here, if you've been involved in the mission of creating family justice centers, our mission is supposed to be to bring partners together in a community, right? That's why this issue fits so well into our wheelhouse, because that is what we are supposed to be about, is bringing people that don't sometimes always talk together or go to lunch together or hang out after work together to work on a common cause that we can all wrap our heads around. Everyone will say to a camera, even those people in outside of Nashville that maybe even are a little redder than Nashville is, will all say, yeah, I want to do my best for victim safety, right? This is a victim safety issue. That's what this is really all about. And I really want to thank the people that have been on this call today. I want to thank really from the bottom of my heart, our panel, not just for participating today, but for participating in this movement for many, many years. All the work and effort. When I start reading even the little snippets of what Julia, Don, Diane, Francis, Becky, everyone has done, I want to do, now I'm blanking on the name, but I used to watch a movie when I was a kid about we are not worthy, and I feel like that in a little way. So I will wrap it up. If there are any more questions. Oh, no more open questions. Okay. I think then we are done. Thank you all for your time. Is there anything else, Aaron, that you wanted to do or say?
Yeah, I just think we have about 5 minutes. If any of the speakers want to just give a last quick recap of anything they think the family justice centers can do. I know the network's going to be supporting them in this work, but if you have any other tips, this would be a great time to suggest them.
Can I just offer just to add to what Marissa, you so clearly stated, a champion is necessary, and it's my experience and belief that the Family Justice Center folks can help create those champions too. So even if they're not emerging organically or immediately, there are ways that we in our various positions can help develop those champions. And so it, again, Giffords is in a position, I'm in a position to assist with convenings, with meetings behind the scenes, with technical assistance, with moving one piece this way and another direction. It's part of what implementation is all about, and it's and what I have the honor to be undertaking in this role that was developed to focus on this, because I had spent so many years in positions where advocates were doing good work, but we weren't seeing the benefits of all of that good work because the implementation wasn't happening. So that can happen, and you all are in such a fabulous position to do that. And with respect to Tennessee, even though our laws are different, we can see we have so much in common and much to learn from the ways you have moved forward with addressing accountability, providing information to increase compliance. And we see it just in the first few weeks of the commissioner being in place in San Mateo County. they are seeing guns being turned in, being relinquished. And in the long history of Santa Clara, implementing the rules of court, the procedures that many judicial officers there helped write, that we wrote at the Judicial Council, we see it that makes a difference. And we have, given the population in California, too many lives have been lost, but we see that we have one of the lowest rates of gun violence deaths as compared to many other places. Still too high, still too many, but there is a connection between gun safety laws and saving lives. So we can do it. We really can. So thank you very much. And you all have such a critical role to play. I look forward to working with you.
I would just like to add to that, what everybody does to always consider having voices, you know, a survivor on your panels and your policies, you know, because they're the ones who are experiencing the violence, and they can have great, wonderful feedback for you that you might not think of. And I want to, as a survivor myself, I want to personally thank everybody who's on here today and all of the panel. You know, October 18th was 41 years ago. I started working in the field of domestic violence. And I can tell you 41 years ago, first of all, we didn't have Zoom or webinars, but you wouldn't have gotten 5 people in a room to even talk about domestic violence. So personally, I thank you for that.
I'd also like to add that champions are absolutely important, and identifying them in every place is important, but having the structure outside of individuals is so important. I think what we see in San Mateo and Santa Clara is that there is a formalized structure for coordination. There's the Domestic Violence Council, and all the partners are really active and in regular communication when issues come up, when laws like SB 320 get passed, and you can put it on your agenda. And so that is so very important, because we know people move around, and that judicial champion you had 3 years ago is in a different assignment or retired. So it's so important to have that structure in place if you don't already have it.
Yeah, I want to agree with that, Francis. I call them popcorn years, when you're almost there and then suddenly something happens and your leader, your champion, isn't there anymore. And so when you come to the new person that took that place, and you have something that's institutionalized and existed before them, will exist after them, it adds a lot of strength to make it through those popcorn years.
My final thought is just to echo what Marissa said. This is patient, persistent work. And that's something we say to ourselves over and over again, having worked on firearms dispossession here for the last 6 years. I think, you know, we naively thought at certain moments we were really going to be there and things were going to be turning a corner. And what we find is that it's a very slow turn. And that is something that can be really frustrating at certain points in the process. It can be frustrating for newer people in the field to say, why don't we just take away the guns? Why is this such a problem? But really, I think those 3 Ps that Marissa highlighted are so important, and especially just that perseverance and understanding that this is lifetime work. I really loved that, because it is something that is going to take all of us for our whole careers, continue to make sure that this is happening and happening consistently.
My final thought would be, it's worked really well for me to celebrate the small and big wins. It really creates those champions. So when you do have a police sergeant who sends his team into a house and gets those guns, that you give big attaboys and attagirls to everybody on the team. And it really helps them feel like they did the right thing and that they're getting acknowledged for it. So that's been a great champion builder. And that's how we built our sticky little network of the yes people, the can-do coalition, as I call it here. But yeah, making it so that you have systems that are not personality dependent, because we do not rise to the level of our goals, we fall to the level of our systems. So putting something in place while you're a champion that will outlast you and all these personalities will set us all up for the long haul. So, but thanks everybody for everything that y'all do. It's so cool to be in this incredibly distinguished panel, and let's go out and get some guns.
Okay, we've been asked, is there going to be access to the recorded webinar to share?
Yes, so what we'll do is we'll turn this into a YouTube video, and then we'll send the link out to everybody so that they can share it with their networks.
Okay, fantastic. With that, I think we'll wrap it up. What I would ask people that are still on the call, when you are done, give yourself 5 to 10 minutes and map out in writing what your next steps are going to be. I have always found that you can go to a training like this, and if you let it go without taking some action within the next hour or two after you're done, things start to slip out of your memory, and then all the things that you have on your agenda, take precedence, and you don't take those initial first steps. Those initial first steps are key. Find out, make a list of who you think could be potential stars, potential people that are going to be your go-to people that are going to help you in this fight. Make a list of those people and what you would expect from them, and ask them if they would be willing to meet to just talk about ways to improve the system where you work, and go from there. And of course, for those of you that are part of the California Family Justice Center Network, we hope on November 1st, we get to see you, whether it be in person or virtually, at our meeting in Sacramento. So that's, I'll end it with another thank you for all of our wonderful panelists, and for Aaron, all your hard work to put this all together. Really appreciate it.
Thank you.
Yeah.